Please be seated. Good morning, everyone. We have two cases on our docket this morning. We will hear first from number PD-0877-24, Dylan Eugene Taylor versus the state of Texas. We'll hear first from counsel for the state. If both counsel, when you approach the microphone, could identify yourself and remind us who you represent, that helps us to keep track of where we are.
Yes, Your Honor. My name is Daniel Sakaida. I represent Hayes County in the state of Texas in this matter. Mr. Taylor parked his car illegally outside the house of the woman that he was stalking. He had a gun in his center console, and when police responded to her 911 call, he was arrested. Subsequent to that arrest for the stalking warrant, the gun was found in his console during an inventory search of the vehicle. He now complains that the search of his vehicle was a pretextual search and that he was illegally searched in violation of the inventory policies of the Kyle Police Department. At the time, he had provided the officers with no reasonable people that could have come to pick up his vehicle. He had offered for his mother to come down from Pflugerville, and the officers denied that as being a waste of time to wait for her to come down to Kyle. He also offered for some unnamed other person to come over and pick up his vehicle. That was also denied. That was all within policy. The inventory policy then directed the officer that should the vehicle need to be impounded, that an inventory be conducted of the vehicle. Now, the inventory policy specifically states that the owner or the operator of the vehicle shall be asked to remove, if possible, all valuables from the vehicle prior to impoundment. If such items cannot be removed, they shall be inventoried before the vehicle is removed, and the owner-operator shall be requested to verify the completeness of the inventory by signature. In this case, the officer did not actually specifically ask Mr. Taylor if there were any valuables left in his vehicle. However, Mr. Taylor was clearly aware that the search was being conducted, and in fact, before the officer even conducted the search, asked for the officer to remove his keys, his phone, and his wallet from the vehicle, effectively covering the valuables that would be expected to be inside the vehicle. When he received those, the officer then conducted the search of the vehicle. The gun was found almost immediately because it was in the center console. Opens up the center console, and there's a firearm.
Did the defendant ask or tell the officer where to look for the items that he specifically requested inside the car?
I believe so. They were able to locate them very quickly, and they did use the keys to go back and search later, so there was no issue getting into the.
So in other words, I'm trying to figure out whether there is when he said, "Get my keys and my wallet out of the car," did he say, "But only look on the passenger seat because that's where I left them"?
I can't recall if it was that specific about where they were. My memory is that they were in the front cup holder, but I could be correct about that from the video judge. In any case, the state is not relying on that as grounds to search the vehicle, whatever statements that he may have given to the officer to go inside. This is strictly being conducted according to the inventory policy of the Kyle Police Department. The officer found the firearm very quickly because it was in the center console, but in the process of going through the rest of the vehicle, took out what's called ticket writer, which allows them to take cell phone photos of the interior of the vehicle, and took photographs of the remaining cabins of the car. This was done relatively quickly because it did not appear there was anything else valuable in the vehicle. The officer did not see anything of value. It was mostly empty backpack, trash, wrappers, napkins.
Did you tell from the photograph that the backpack was empty?
It appears to be empty. The officer did not go into it specifically, but his recollection was that it did not have anything of value that he noticed, and the defendant did not instruct him that there was anything of value in that container either. The receipt that's generated by that contains those photographs, contains a signature line for the towing person, and contains a signature line for the defendant. The signature line for the defendant was never presented to him, and he never signed it in this case. And the officer testified that he has never actually presented that to any defendant to sign.
So let me jump to something important first, which is, do we have to overrule our Mowbray case to go with you, to decide in your favor here?
No, Your Honor. I don't think that Mowbray actually needs to be overruled. I think there just needs to be some clarification.
Should we anyway?
Possibly. It has some issues. I think the language in it is unnecessarily harsh, and I think the must not deviate language is confusing to the lower courts. It's been
Do you think it's
applied-
harsh or inconsistent with itself?
Yes, Your Honor. I think that it's internally inconsistent, and I think that it creates issues for clarity. And specifically, just for the facts in Moberg, that was regarding a search of a motel room, and San Antonio Police Department attempted to use the inventory policy to inventory a motel room that was clearly not covered by the inventory policy. This was subsequent to them obtaining a warrant that after obtaining they realized was, for various reasons, not going to work.
To take you back to Judge Urie's question, isn't there language in Moberg that would be fatal if it were taken literally in this case? I mean, it seemed to indicate at one point that there must be effectively strict compliance with whatever the relevant policy is. Would you concede that your officer did not? Or maybe you would, that's the question.
Well, I think your characterization of the language is correct in one reading. The specific language that's been adopted or repeated by many of the lower courts has been that the officer's actions must not deviate from the written policy. And courts have varied in how they apply that. Some have been applying a substantive and non-substantive difference. In this case, my argument would be that I believe that the officer actually did follow the policy. Carefully reading the policy, there were no valuable items that he was aware of in the vehicle. The defendant was given an opportunity to remove the items, which he stated to be removed from the vehicle that he thought would be valuable. And just because the officer has never before asked an individual to sign that slip doesn't mean that that would be necessary in many cases. The only time that under their policy that one would be required to do so would be if there were valuables in the vehicle which could not be removed.
But if I understand your argument correctly, to get strict compliance with their policy, you have to accept that there's a difference between, I think there's 3 paragraphs in that policy, but if he's taken something to be used for investigative purposes, you count that as not a valuable.
That is correct. And that is the last paragraph, number 4 of their own policy, clarifies that anything that is contraband or evidence in the case. In this case, the defendant had multiple prior felony convictions, making him ineligible to own a firearm in Texas, which was the basis for this conviction. Because the gun, therefore, is contraband in this case, their policy demands that it be treated as evidence.
Well, it wouldn't be contraband unless you knew he was a felon. At the time he took the gun, he didn't know that, did he?
Initially, he did not. They did run him both to see if the gun was stolen and for his background. And by the time that they actually completed the rest, they knew that was the case.
Counsel, the complainant in this case informed the police that she believed the appellant had a gun, correct?
That is correct.
Okay. So when the officer went into the vehicle, he found that gun within 30 seconds, correct?
Yes.
He then investigated the gun for the next 5 minutes and 30 seconds in order to attempt to obtain the serial number.
Yes.
He was attempting to obtain the serial number to determine if the gun was stolen.
Yes, sir.
How is that not a criminal investigation?
That's their policy at this point.
Hold on. Their policy says, an examination of the contents of a motor vehicle pursuant to a criminal investigation or with the intent to search for evidence is not an inventory, but a search. That's the black letter of the policy. So if he spends 5 minutes and 30 seconds investigating the gun to determine the serial number for the purposes of a criminal investigation, how is that not a black letter violation of the policy?
That would be the case if he had found any item that would be contraband. He would have to investigate to see, first of all, in this case, if it was contraband. Here, he was running the serial number to determine if it was a stolen firearm, which of course would be a
And
total
how is that
offense.
related to the inventory search?
Because it would determine how this item would be handled by the officer as well. If, for example, in a hypothetical case, if they had shown up to the scene and they had opened the trunk and the complainant's body was in the trunk, there would be substantial acts in investigation that would happen. It wouldn't simply be open the trunk, oh look, there's a body, check that off the list, move to the front of the car.
No, I understand that, and of course you're right. But my question here, of course you're right, but my question here is, and one thing I would like to clarify first. You said at the beginning that he was sitting outside the woman he was stalking. He was arrested on a stalking warrant.
Correct.
Was this complainant the woman in that stalking warrant?
Yes, Your Honor.
Okay, so he's arrested on a stalking warrant, or rather, he has a stalking warrant outstanding. This woman calls and says, the guy's outside my house and he's got a gun. The officer goes into the car, 30 seconds, finds the gun, spends the next 5 minutes and 30 seconds with the gun, and then spends less than 3 minutes to take 4 photographs, and that's it. And the state's position, that's an inventory search.
That is an inventory search pursuant to their policy.
What was in the glove box?
That is an area he did not look into, and he probably
Wouldn't
should
the
have.
glove box be area number 1 under this police department's policy that you would have to look?
Yes, to be clear, that was the glove box in front of the passenger seat. The glove box just to his right is where the firearm is found.
Understood.
Just so we're
Between the
clear, yeah.
console, he looked,
Correct, but he didn't look in the one that was in front of the passenger seat.
and he didn't look under the passenger seat,
No, he did not look under the seats.
and he didn't look in the backpack,
Correct.
and he didn't look under the debris that was in the rear seat.
Correct.
So just tell me this. What action did this officer take to preserve the property of the arrestee?
So, yeah, I understand you're getting to the policy concerns here too. And part of the issue here, I don't want to imply that the photographs were a substitution for the list. I don't think that's the case here. The photographs are helpful in that they identify what the areas looked like. The defendant had already known that this car was being searched and asked to remove the items he thought he needed to be removed from the vehicle. He didn't give an indication that, oh, there's a stack of cash under the driver's
But he was
seat.
never asked if there were any other
He was
valuables.
never directly asked, but
And no other valuables were identified because no other valuables were searched for.
no one was searched for. But because he didn't identify anything else that he wanted removed from the vehicle, he was clearly aware the vehicle was going to be towed, given his actions and his requests to have his mother or some other random person come pick up the vehicle and asking for the items to be removed. He's a felon, he knows how the system works, he knows what's gonna happen next year.
Given that the complainant informed law enforcement that she thought he had a gun, is there not probable cause? Is there a reason why the state didn't argue that there is probable cause to search the vehicle, and so the vehicle exception applies?
I do not know that she said specifically that she saw him take a gun to the vehicle. My recollection of that 911 call has been a little while since I listened to it. My recollection is that she is aware that he carries firearms regularly. And that, in my opinion, would not be probable cause to search the vehicle, just knowing that he is known to carry firearms.
You don't think
If
that
she
would-
had seen one specifically that day, absolutely.
Can you tell us exactly what the complainant said about the gun? Because I've heard 2 or 3 different versions of the actual wording. Did she say he's got one, she thinks maybe he has one, or he's been known to have one, or, you know what?
Let me pull up quickly, Your Honor, hold on. So the actual statement was that she had seen him spying on her from the vehicle and that he was known to carry a gun. He also denied the presence of a weapon in the vehicle. That obviously also does not give rise to probable
Okay,
cause.
known to carry a gun.
So counsel, let me ask you this, pretend you win, but we don't want to overrule Moberg because Moberg's about a hotel and this is about a car. Like what does the last paragraph of our opinion look like where you win, but we don't overrule Moberg?
I think upholding Moberg in this circumstance is relatively simple because the violations that happened in that case led directly to the search happening. They are the underlying reason why the search occurred in that case. Had they followed policy, there would have been no search. Subsequent to the finding of the contraband, we might need to develop a test for if there is a substantive or non-substantive violation of policy, or have a burden on the state that there's a presumption that it's pretextual at that point, but that can be overturned by showing some evidence. In this case, I don't see evidence that there's a pretext for this search. The officer is going to have to tow this vehicle. It needs to be moved to the scene where it's at. It's illegally parked. And having the defendant come back to the scene where the person he has a stalking warrant against to pick up the vehicle is not gonna work either. So he needs to physically come back and remove this vehicle. That's going to happen. As he's proceeding through this, he does it in what one might call a slipshod manner. He just takes photographs, he doesn't dig around. He should have probably done a better job doing that. But at the end of the day, the test should be something along the lines of errors that do not lead to the discovery of the contraband or the evidence in question should be reviewed either to see if there's substantive, large variations from the policy, or create a rebuttable presumption that there's a pretextual search in this case that can be rebutted by the state.
Can I ask you a question?
Yes.
Are you saying that the deviations from the policy, the arguable deviations, happened after the gun was found?
In this case, yes, they all occurred subsequent to the finding of the firearm.
And so that, in your point of view, that would not support suppression?
In general, no.
Even under Moberg?
Yes, even under Moberg. There might be circumstances where the actions that occurred subsequent could indicate that this was a pretextual search. For example, there's cases where the inventory form was simply never filled out at all.
But that was here. There was not a list made at any point with any items.
That's correct, but that was subsequent, that was subject to their policy, which only requires listing valuable items. I grant that the search may have uncovered more, but there was none that was found, and the policy only required
So the state's
listing.
position is they didn't have to make a list of the things the policy would have had them make a list of, because they didn't bother to look for the things the policy directed them to find.
In this, I'm sorry, I'm over time.
Yeah, go ahead.
I think that the officer, again, should have done a better job, but in this case, the lack of finding the items and the lack of searching for them is not a substantive variation from the policy. It's simply a poor execution of the policy, perhaps, but it doesn't mean that the policy has been violated in that way. He did follow the policy, which required that if there's valuable items that cannot be removed from the vehicle, they must be inventoried. Those are the only items that the policy requires inventory of in the list. There was none found, and so there was no need for.
But there might have been in the glove box. There might have been in the money in the console. There could have been under the seat. Might have been in the backpack. He just didn't look.
Sure, and then there's a question of how far he should have looked. Should he look in the engine compartment as well? Should he look under in the
Glove
tire
box?
compartment? The glove box is probably one that I think the policy probably should have covered. But again, that would be a in my
Policy
opinion.
did cover.
No, that's what I mean. The policy covered that the container should be searched. And in my mind, that be happening subsequent to the finding of the firearm is not a substantive difference here and would not have affected this. It does mean that it was a slipshod, perhaps, investigation, but it doesn't mean that it was a pretextual search.
Thank you. You have some time for rebuttal.
Yes, thank you, Your Honor.
May it please the court, counsel. Good morning, Your Honors. My name is Vikash, Bhakta, and I represent the appellant, Dylan Taylor, in this case. Your Honors, today, under the guise of latitude, the state invites this court to expand police discretion into unconstitutional territory. This court should reject this invitation on several grounds, primarily on Supreme Court case law. Now, I want to give a brief background about Supreme Court cases discussing discretion, specifically when it comes to following police policy. It starts in 1976, but I'll start my analysis in 1987 in the Colorado v. Bertine case. In Bertine, the facts are similar. There's an arrestee, there's a vehicle, it's impounded and searched, and contraband is found. In Bertine, the policy empowered officers to make a judgment call as to whether they would impound the vehicle or not. If a vehicle was on private grounds, the police officers could have chosen to simply leave it there. Here, they chose to impound it, and of course, contraband was discovered.
I guess the starting point is, do you think there was any discretion on whether they should tow it or not?
Right, exactly.
Is your position they should have just left it there?
Well, in Bertine, I think they could go either way.
Okay.
And the Supreme Court ends up saying that so long as the discretion is tied to standardized criteria found within the policy, that's okay.
Okay.
Now, the next chance that they got to look at standardized criteria found within policy was Florida v. Wells. This was, to put it plainly, a very weak opinion. The majority opinion, while stating that discretion should still be grounded in standardized criteria, ends up stating that officers be allowed some latitude in the enforcement of inventory searches. Justice Blackmun and Justice Stevens rightly criticized the majority for this. Justice Blackmun essentially stated that while you're upholding the ruling that standardized criteria need to be abided by and adhered to, essentially with this dictum, what you're doing is spawning a circuit split, and that's exactly where we've ended up. You can now blow up the standardized criteria by simply stating that officers have latitude.
Is that the most recent opinion, though, from the Supreme Court that talks about this, or is there something that comes after it?
I haven't found anything else, Your Honor. Florida v. Wells seems,
Which, if any, of these U.S. Supreme Court cases, putting aside our Moberg decision, focuses the inquiry for the trial judge in exercising discretion on the motion to suppress on the fact of the inventory search as opposed to how well documented the search is in compliance with whatever the local policy is?
I think that would be Wells. In Wells, it seems to suggest that the trial court look into the facts of the case. Because of what may be happening during the search, the officer may be given some latitude.
Right, well, what I'm looking for is the U.S. Supreme Court decision that helps you in the way Moberg would have helped you with the way the officer documented the search which he did, which would be justified as against any attack on a pretextual rummaging exercise to find evidence, that the way the officer documented it was not in compliance with something that the HR department could certainly enforce, but why would we be looking at that as a Fourth Amendment problem?
I think because it allows the officers to undercut the caretaking function. So let me quote the Fifth Circuit case that I read. It's Hope. So this comes after the Wells opinion. It was the Fifth Circuit in United States v. Hope, essentially stating that an inventory search is reasonable if it is conducted pursuant to standardized regulations and procedures that are consistent with, one, protecting the property of the vehicle's owner, protecting the police against claims or disputes over lost or stolen property, and three, protecting the police from danger. So I think the second part there would seem to suggest that even though this may seem like ticky-tacky, the inventory forms.
But doesn't that go to the purpose of the search, not the manner in which the search is conducted? Why, I mean, to cut to the chase, if we had an officer who was perfectly complying with the form and reporting requirements, say it had a requirement that you must type the document up in a sans serif font no smaller than 12, and he does that every time very carefully, but he only selectively searches vehicles to comply with based on his suspicion he's going to find something. Isn't the problem the latter problem? Why would we care what font the officer is using or how timely his report is? Or in this case, I can see an argument that his manner of inventory was a lot better from the police department's perspective of protecting against conversion claims than filling out a piece of paper. If he'd found a watch in that car and he said, junky ancient Chinese watch, and now the owner comes back and says, no, that was a Rolex. But, I mean, the video would be a lot better than a piece of paper, wouldn't it?
Yeah, but once again, we'd be tied to Bertine in this case, because I think Bertine is still good case law. And so long as the police officer's actions are tied to the policy, I think we're required to do the form in whatever font that is required.
But isn't the purpose of the policy insofar as the Fourth Amendment is concerned for all of these cases? I mean, the Supreme Court's, I think, been pretty clear that the goal is to prevent, what is it, rummaging?
Yeah.
In order to search for evidence of criminality. As long as the purpose is to avoid claims of spurious or otherwise of damage to property or lost or stolen property, why do we care on this side of the world to the way the search was documented?
Well, it's a very good question and would seem to suggest the majority's opinion in Florida v. Wells. If we were to take that position, that there are some things that this court should not care about, even then, just to get back to the facts of this case, I think this is not the case that we answer that question. Here, the officer, as Justice pointed out correctly, failed to search the glove compartment as required by policy. He failed to get the signature as required by policy. He had substantive violations, and I think the most egregious of them all was simply not doing the inventory.
Can I ask you something about that? Two things, actually. Do you agree that the deviations from the policy here occurred after the gun was found?
Sure.
And so the deviations didn't have anything to do with the discovery of the gun, right?
Well, I think they got the permission to get inside the vehicle because they were doing an inventory.
So you're contesting the inventory from the get-go, is that
Yeah,
right?
absolutely.
So
I
you're
think-
saying it was illegitimate from the start?
And it has to be. Even if they had found the gun at the end or the beginning or the middle, the point of it is the police officers get to access somebody's private property under the Fourth Amendment, under this exception, so long as that search is reasonable. And here, for it to be reasonable, they have to inventory everything in there.
So
Wait a minute,
they
it's
have
more-
to rummage? Wait a second. This is the second question I want to ask. Here we have a lack of rummaging. You're saying they needed to rummage,
Yeah, not just for criminal evidence, right? So
but
they
they
need to
just
rummage
needed
for
to
his
really be
valuables as
thorough.
well.
And if they weren't thorough, then
Yeah,
the little fruits they did gather have to be suppressed.
exactly.
So they had to violate the Fourth Amendment more to not violate the Fourth Amendment?
In a way, yes. Well,
But it has to be a
fortunately, there
good
is
faith
guidance.
search, right?
Excuse me, Your Honor?
A search without a warrant is unconstitutional. In order for an inventory search to make an exception, it must be a good faith search under both our law and SCOTUS, right?
Yes.
So if the inventory search was fatal because of some things done at the end, the fact that it was found after the gun makes no difference whatsoever if those things add weight to whether it was, i.e., a pretext search or not done in good faith. If it's not done in good faith, it's a bad search,
Yes, Your Honor.
per se.
Yes, Your Honor. And fortunately, this court has given guidance exactly to this issue. It's been 40 years since then, but in a case called Galdine v. State, again, similar facts. You've got an arrestee, you've got a vehicle, the police go inside a vehicle, find contraband, and actually it's pretty close to the facts of this case. They start the inventory search, find the contraband, and conclude the search then and there. It's very similar to what the officer did here. And this court, 40 years ago, concluded that an incomplete inventory search is an invalid inventory search and therefore not reasonable under the Fourth Amendment.
Here's a concern that I have, is that we are, it seems like on one level, we are inquiring into what the motivations of the officer on the scene happened to be. And I'm guessing that the officer on the scene was called to testify at a motion to suppress hearing, and the trial judge, correct me if I'm wrong, but didn't the trial judge uphold the search or refuse to grant the motion to suppress, the trial court?
In Galdine or here?
Here. In this case, the
Here.
appellate court reversed.
Yes.
But the trial court, I think, decided to not suppress the evidence. And so, did the trial court, ordinarily, the trial court's in a better position than we are as the appellate court to look at the witness while he's testifying, to decide whether or not that witness is being truthful to the degree that he's saying, well, my motivations were this and not that. So, are we being asked in this circumstance then to invade the province of the trial court judge in making an assessment about the true motivations of this officer when he started to conduct that search?
Well, I think there has been some case law that suggests that an appellate court could view video evidence under a different standard.
Okay.
So here, when we're looking at the video, the trial court might have seen one thing, but the appellate court is not.
That goes to actual facts that happened. Does the video necessarily speak to the motivations of the officer?
Not necessarily, no, but they strongly indicate the motivations of.
Yeah, but somebody has to have the job to decide what those historical facts were, right? That he had this motivation or he had that motivation. And so once the fact finder has made that, shouldn't we be careful about invading that fact finder's? Did the trial judge make findings of fact in this case?
No,
Was he asked to make findings of fact?
No, I don't think so. But I think, Your Honor, in this case, it really wouldn't matter what the officer's motivations were.
Okay.
His duty was to abide by the policy.
Right.
Well,
And he failed to do so.
isn't your point that we would give almost complete deference to the fact finding on motivations to the extent you can infer it from whatever the trial judge didn't document? But if Moberg's correct in its detail, and as some courts of appeals have said, you have a legal argument here, right? We wouldn't owe any deference to the
Right.
trial court's determination on the law, right?
Can you address how Cox applies to this case, if it does?
Your Honor, Cox is pretty similar in terms of at least the video evidence. The state, and I think the dissent as well, are relying on the fact that there was video evidence showing some parts of the car, and they're attempting to substitute video evidence for actual rummaging through the car and actual inventorying of the valuables in the car. And Cox points out several problems with this. this. One, the officer's not narrating what he's seeing. The video quality is unclear and very quick. I mean, he spends like seconds on this thing. And worst of all, and most egregious of all, the officer on the stand on page 49 and 45 admitted that there could be valuables underneath the parts that were videotaped. So I think Cox, at least the reasoning in Cox, should be applied regarding the videotape evidence. And probably the best argument in Cox that applies here seems to be that the officer can't simply, on his own, decide that I'm gonna substitute video for paper. Now that may seem ticky-tacky, but there are reasons for this policy. And
So forgive me for this question, but how many words is a picture worth?
maybe not a lot, especially if it's a moving picture. I mean,
AI is gonna make them worth
yeah,
zero,
and then there's
right?
that, you know. So, I think Moberg isn't on its last legs. So if you look at even Florida v. Wells, you've got Justice Blackmun and Justice Stevens strongly advocating for a bright line rule. And without the bright line rule, what you're gonna have is chaos. I mean, any trial judge could decide, okay, well, you know, this is latitude and this is not latitude. And no court has explored this, that what should be latitude. Not even Wells. I mean, Wells, it's just addressing this in dictum.
But
So-
that gets to what I see as the core question, for me at least, is what are we looking at here? Are we looking at the motivation for getting inside the car and looking, or are we looking at the manner in which the thing was done? And I certainly see the manner, but if the motivation is to protect the police department against claims of theft and, you know, conversions of chattel, then why does it matter how the search was conducted? I can see the factual argument, getting back to Judge Finley's questions about, well, he says he was coming to protect against lost claims, but the fact that he didn't follow the policy is some evidence that that wasn't what was on his mind. The fact that he knew there was a guy who was potentially scary and was carrying a gun. As soon as he found the gun, he stopped looking in the glove compartment, et cetera, et cetera. But aren't those all arguments to a fact finder that we would not completely defer to, but almost completely, right?
Yeah, I mean, I would have to, you know, split the baby there and say it's both. It's not just the motivations, and I think a lot of these cases aren't decided just on the motivations of the officers. They're decided on what they actually did, even if we view it from an objective standard. If the officer had the motivation to find the gun, but he completed the inventory, I think it's okay, because he gets to do that. He gets to find things in the car, and some of those things may be contraband. But if he failed to complete the inventory, as he did here, I think we're getting into complete discretion.
I guess that's my question. I'm getting back on what Judge Keel asked you, is that if the officer has, his intentions are correct and legal in looking for the item in the vehicle, he finds it, and then subsequently he messes up the paperwork, he doesn't do something consistent with the policies, does that invalidate the discovery of the weapon?
Right.
And does a violation of police policy rise to the level of a constitutional violation?
I think this
Is that your
question-
position?
Well, I think this question should be punted forward, because the facts of this case don't require this court to answer that question. Is that, do small violations invalidate a mostly proper inventory?
But he knew there was, he had information that there was a gun in the car, so he had a valid reason for either doing an inventory or just protecting himself, right?
Well, he had a valid reason to do the inventory because the car was parked by the stop sign. So I don't think it matters whether there was a gun in there or not. His reasoning, at least from a legal point of view, what vested or what gave the officer the right to access the vehicle was because it was illegally parked or potentially illegally parked. There's some debate on it, but
And if he doesn't sign the right paperwork or something, then your position is he's botched the inventory, so it's invalid.
well, you know, my position is that this court is not required to answer that here. Here, there are substantial violations of the policy.
But they happened after the gun was
Right.
found?
Sure.
So you would relate back those deviations to the beginning of the search and invalidate the whole thing?
Under Galdine, it seems to be that you have to complete the actual inventory process. You got access to the car because, you know, the car was illegally parked or parked in a private space or whatever the case may be. And once the police gain access to this, they have to adhere to their own policy. And I think if this court goes down the line of deviations, yeah, it could spawn case law, which would make it impossible for an officer to function. And while Moberg may be detested for being hard and fast and mechanical, at least it's clear, you know? And that's one thing Moberg has going for it, is that it's clear. It's a bright line rule. You have the policy, you abide by it, and
Your argument is that it's mechanical, and the U.S. Supreme Court, who is more authoritative than us on the meaning of the Fourth Amendment, says that it can be, whether it's mechanical or not, or or all or nothing. It's not all or nothing. It's not just a question of is it mechanical or is it not mechanical. So how do we? I mean, we're supposed to say, oh, the U.S. Supreme Court didn't go far enough when they were talking about the Fourth Amendment.
I think it's now become a difficult line because of this language in Wells. But that language should be criticized properly, because if you look at Justice Stevens' opinion, concurring opinion, they're harshly critical of this, in that, you know, what you've now done is blown up the standardized criteria. And while we may say, well, the fonts are required and those requirements are ridiculous, and they might end up creating a situation where a search is rendered unreasonable when it's 99% compliant. But at least it's possible to comply with this.
Counsel,
On the other hand,
go back to good faith for me just for a second. Assume this officer in this case performed this search perfectly. But at the trial court, he testifies, my intent was to find the gun. Then how he performed the search is absolutely moot, and it is a bad search done in bad faith, correct?
I would disagree.
Okay, why?
As long as, I think his intentions are not as relevant as his actions.
So doesn't that belie the assertion that his search has to be the inventory has to be done in good faith?
Well, if he's complying with the inventory procedure, it's in good faith.
Then his motivations are immaterial?
Exactly, yeah. I mean, they're police officers, they're searching for contraband. This is kind of it's a given, you know, but as long as he complies with his policy, I think the individual officer's intent and what he's looking for in the car are irrelevant. As long as he collected the arrestee's materials, valuables, whatever items there were. And
Well, you seem to be ruling out the possibility of there being a policy that on its face is unconstitutional for go searching for microfibers of cocaine that might be in the carpet. I mean, if that were within the policy, it'd be within the policy, but the policy itself could be beyond the scope of a reasonable inventory, right?
Right. I think the court would be called upon to fully illuminate what the word standardized criteria mean. Standardized as to what?
And just to be clear, you're arguing just the Fourth Amendment. You don't have a state constitutional argument here, right?
I think I made the state argument as well, but I've got the U.S. Supreme Court authority is stronger, so. So if
Well, you take a few seconds and tell us what we should do.
I think Your Honor should punt. I mean, this is not the case. This is not the case to decide Moberg is good law or not good law. I mean, it's a good chance for dicta to create further problems. But it's the Fourth Amendment. You know, it's just Thank you, Your Honors.
Thank you both very much.
Counsel, before you start, let me ask you a question really quickly. The inventory search policy was at least fairly long. There was many items they're supposed to do. The only item they did do was open the door, get in the car, open the console and get the gun, and that's it. That's all they did, right?
I think it's undercharacterizing what the officer did. He did go into the remainder compartments of the vehicle.
Took some pictures,
He took photographs, yes.
which is not on the list. But as far as the list, the only thing you did was open the console and get the gun. How could this not be pretext? I don't understand your argument.
So, for one, just to partially answer, take one step back. The Fourth Amendment, the ultimate touchstone is always reasonableness. Here, the actions that happen after the finding of the firearm don't necessarily show us that he was acting pretextually just to find the firearm. Here, he does go into the remaining areas of the vehicle. If he had stopped when he found the firearm and simply not completed an inventory at all,
Stop for 5 minutes, 30 seconds to run the serial number of the firearm, which is what he did here.
which I believed he would testify that he was required to do by department policy for firearms.
And
as
if he
part of
was
their-
really trying to follow the policy and follow the rules, wouldn't he have done at least a few more things?
I think that we might be able to say that. We might also be able to say that it's deference to the trial court judge here as well. It's correct, there were no findings requested or made in this case, so we have to infer findings of fact here. And the findings would have to be that he at least conducted some sort of a search through those other areas of the
Let me ask you this, I'm sorry, go
Go
ahead.
ahead.
Let me ask you the same hypothetical I asked opposing counsel. Assuming this officer in this case did the search perfectly, but testified at the trial court that his intent was to find this gun, does that invalidate the inventory search?
I actually meant to bring this up in the first time. I think yes.
Okay,
I
and
think
that's because Wren, the Supreme Court case, specifically says the exemption is not accorded to searches that are not made for caretaking purposes. Investigatory searches under the guise of a vehicle inventory are bad faith vehicle inventory searches and accordingly unconstitutional. That's the black letter Supreme Court law.
Yes, Your Honor, and I think that it could come up in testimony. It could have come up, you see a lot of things in body worn cameras now. The officer could have been getting to the scene saying, I gotta get in that car and see what's in there.
So then balance this for me. If this court watches the video and seeing the video concludes it's a pretext, how much deference do we give to the trial court? Where is the mix of the trial court's discretion as to credibility versus the de novo aspect of the application of the law here and our ability to watch the video?
So part of it, the factual side regarding, first of all, the officer's credibility is obviously gonna have to come down to the trial court judge. He's the only one that was able to see it at the time. Regarding the steps that he took, we're going to have to infer that he took the necessary steps, again, because there's no written findings of fact here. This is more complicated because he doesn't actually have written findings of fact, and them were requested. But the court would have to define what, when it gets to an admixture between, like I said, the application of the law, obviously on review, we can get into that more. But I think that most of the issues in this case are factual, and they relate to what the officer testified to.
So try to answer my question one more time, in the little bit of time you've got, is how in the world is this not pretext? Wouldn't you agree that the average person, you know, reading all this would say, he was looking for a gun. He wasn't trying to do a valid inventory search at all, because once he found a gun, he just quit. Didn't do anything else.
So the firearm obviously, I think, changes once he finds it. This is why I think the before and after distinction is important. It doesn't necessarily mean that he was only looking for the gun, but once you find the felony there, that does change what's going on in the officer's mind as he's searching through the vehicle. He does continue to search the vehicle.
Although he didn't know it was a felony at that time.
At that time, that's why he has to run it according to their policies, all that sort of stuff. He has to run it for the serial number and all that.
And
But
he didn't do nothing after he found the gun.
yes, and that's the remaining part, is that he does go into the remaining areas of the vehicle. He doesn't go into the glove compartment, he doesn't look under the seat, but he also doesn't go into the front bumper or see if there's something hidden in the tires, like you might do a border search or something like that.
Did he tow the car?
The car was towed and was not for by the tow operator.
Didn't look in the trunk either.
He did look in the trunk, there's no photographs of it. It's very brief, it's very dark, but he does go into the trunk. If the concern here really is that we're not protecting the police department against claims of, you know, conversion or theft from this individual, then that's honestly on them to train their officers better. I don't think that that's a Fourth Amendment issue that results in the reversal of this search.
That brings up one other issue. The state has seemed at several times to make the argument that, hey, you know, as long as the officers were complying with their standard policy, it was all right. Are you making that argument? They're not the standard policy, I'm sorry, but their ordinary course of conduct, the way they did things.
I think that the following the ordinary policy is indicative of this not being a pretextual search.
But then go further. So let's say that the officer's standard practices, not their written policy, but their standard practices, are just to egregiously violate the civil rights. Then because it's their standard practices, it's okay. They don't have to follow the actual policy because nobody requires a signature. Nobody creates an inventory, which is what this officer literally said. I never required a signature and I'm not aware of any other officer doing it either. So they can have their standard practice be egregiously unconstitutional and take the place of the written policy?
I think if the practice was unconstitutional and there was testimony to that effect, that would be a different case than what we have here.
So then their standard practices, if they deviate from the official policy, don't matter at all.
They can be indicative to this court if the specific search was pretextual. In this case, what the officer says about the signature is understandable. The policy is that you only have to have them sign that line if there's an inventory of valuables that cannot be removed from the vehicle.
But the officer testifies he's never,
Correct.
ever had anyone sign the signature.
And I think the policy was written that way to avoid running into that situation. I can't think of many situations where an individual is being removed from a vehicle that they can't take the valuables with them. If it's a watch, phone.
You're
those-
saying the policy requiring a signature was written in such a way so that no signature would ever be required.
Not necessarily that would no be required, but that it would not be necessary in many cases.
So you're saying the policy requiring a signature was written in such a way so that no signature would ever be necessary.
It's possible, I don't know, there's no testimony to that effect, but it is possible. Here, and that-
I believe Judge Erie may have one more question.
Yeah, just real quick, you know, I recall a U.S. Supreme Court case called Wren and a Court of Criminal Appeals case called Crittenden that suggested that the Fourth Amendment requires an objective observation of what went on in the court below and with regard to the facts of the Fourth Amendment inquiry. Why are we in this case, it's a Fourth Amendment case, right? Why are we delving into subjective motivations rather than objective observations here? That's something that I don't know, it's in the back of my mind. I don't really see a lot of briefing on it from the parties here, but
There is not
I'm,
a lot of briefing on it.
yeah, I'm curious.
If more was requested, of course, we would provide that. That was not really the issue with the court below. I didn't do the briefing in the court below, but it wasn't really the issue in the Seventh Court of Appeals, so. it didn't
Thanks.
really
I know
get
it's
into
just a random thing, and I just wanted to make sure that I threw that out there to see if you guys had thought about that.
No, but I believe you're correct. I think that at the core, this, one of the reasons the case should be upheld.
Thank you.
Thank you, Your Honor.
I thank you both very much, very fine oral arguments. I'm looking at my colleagues and trying to decide if we should stay out.
Or take a break?
Consensus?
That's up to you.
Yes, stay out?
Up to you.
Yeah, let's say.
We'll call the second case if we have counsel present.